Hi guys, and welcome back to Contract A. We are doing the videos for week 3, capacity to contract, and this is part 2. So we've just finished off talking about contracts that may be binding on a minor, notwithstanding the general rule that contracts mostly won't be binding against minors. And let's jump back in. So that's the issue of employment contracts, one of the two types of contract, necessaries and employment contracts, that will probably be binding against a minor. There will be some exceptions. The next type of contract that you might find with a minor is one of these little babies, and these are contracts that are binding unless repudiated. And that seems like a lot of legalese, doesn't it? It means that the contract will generally stick unless the minor takes some action to repudiate the contract. That is to say that they don't want it, okay? They disaffirm it. Now, what I need to do here is explain a little bit of terminology to you, because you're going to come across this terminology time and time again in your degree, and particularly in the study of contract. And you must be absolutely clear on what each of these terms mean, because law students routinely get confused what this stuff means. You will find judges lapsed into the wrong terminology. And I hate to tell you, but the text also tends to, in at least one heading, slip into inappropriate terminology. So what you guys need to do is be completely on the ball and say, aha, I know what each of these little things do.
Oh, hey, I think I know what that means. That's one of those sentence enhancers.
If a contract is binding, obviously, that will start at the very beginning, and the most obvious, it will stick. It will be enforceable in court. And unless something goes wrong somewhere along the line, the contract will be performed by the parties. If a contract is completely void, that means that so far as the court is concerned, that contract never happened in the first place. Okay? So, where a contract is binding, the consequence is that it will have to be performed, unless something goes wrong. Where a contract is void, the consequence is that the court says, hey, that never happened. Nothing to see here, okay? That has its own consequences, and they are very serious so far as transfer of property goes. If a contract is void, it means that that contract will not have been effective in passing the title to any property from one party to the next, okay? Because it never happened. So the title is still with the person that the title was originally with, okay? That is where a contract is declared void. Where a contract is voidable only, it means that it will be valid and enforceable until a party decides to act on their right to avoid the contract. And what they will do is they will seek an order from the court to rescind or set aside the contract, okay? Once again, a voidable contract will... You were wondering what I was doing there, weren't you? Will proceed according to its terms until one of the party who has the right to avoid the contract puts their hands up and says, no, sorry, runs to court and says, can you please rescind this for me, or set aside the contract for me. Okay, they're the two terms of art you need to know. Rescind, putting up my hand, please rescind, please set aside the contract. And because that contract is valid until it's been avoided, by the party entitled to do so, it means that title will pass from the person purporting to transfer it across to the next person. Now, what that ultimately means is that it's only an equitable right to get that contract set aside, and if somebody else more innocent, a third party, steps in on the end of the line into this bargain, it means that title will pass to them and the original person won't be able to get that property back. Okay, so for example, if you have a car being sold by a relatively innocent person to a rogue, and this is a case that you'll do in contract B, that rogue misrepresents themselves in some way and says, I'm a famous person, please sell it to me, or some such thing. Now, in that circumstance, the car has been sold to the rogue then on-sells it to a third party. Then the original party wakes up and says, oh my goodness, I have had a misrepresentation made to me. I wish to avoid that contract. I want my car back. But then the court says, hang on a minute, that contract was valid until you put up your hand. The problem was before you put up your hand, the property's been transferred to a party we think between you and them is probably more innocent than you. And why is that? Because really, at the end of the day, you probably should have looked after your own interests a little bit better before you let that car go. Okay? So very serious difference in the consequences between a contract that's completely void and a contract that is voidable in equity. Okay? Voidable in equity, that title can pass unless and until the contract is voided. Now, keep that fresh in your mind. Where a contract has been terminated, it means that a party has been performing their contract and it's chuffing along quite well. Something's happened and one of the parties has done something like said, I don't want this contract anymore. Now, if that's what's occurred, that party has repudiated the contract. Now, normally, a repudiation of a contract, and again, you'll get to do this in contract B, a repudiation of a contract is a wrongful act, okay? It's considered to be a fundamental breach. And in that case, the party that is wronged can sue in damages, okay? But here, where we're talking about minors and this particular class of contracts, the contract will chuff along quite nicely unless and until that minor says, don't want this contract anymore, okay? In that case, the contract is chopped off where it stands. It's not unpicked to the very beginning as though it never happened in the case of a void contract, okay? Void contracts, unpick it to the beginning, never happened. Termination that is consequent upon a repudiation chops that contract off midway. Whatever's happened up to that point stays on foot. It's only the future obligations that are discharged, okay? Hope that made sense. If it didn't, email me, post something to Facebook, put something on Moodle. But this is terminology that is crucial for you guys in both contract A and contract B, so you need to be crystal clear. We can go over it in the Zoom if you wish to. But this class of contracts that I'm going to talk to you about is contracts that a minor can repudiate, okay? Keeps the contract there up to a certain point and discharges it for the future. So, you will see in the Norman Baker case, the courts just basically described exactly what I've been saying to you about contracts that are binding unless they're repudiated. Upon the infant repudiating, she is simply freeing herself from further obligation. She is not rescinding, okay? Rescinding occurs where you're trying to avoid the contract in equity. It is a voidable contract that you are asking a court in its equitable jurisdiction to rescind for you, okay? To set aside for you. She is not rescinding the agreement as from the beginning. She is simply bringing it to an end so as to escape from future liability. Here, contracts are binding on the minor unless repudiated, and as a consequence, because the contract's on foot until the time of repudiation, it is effective to transfer over money, property, and so forth, and you can only get it back if there's been what we call a total failure of consideration. And we will go into that much more in Contract B. Bookmark it, I guess, for right now, but that is, in essence, what happens when you have a contract that is binding unless repudiated. What are the contracts that fall into this category with minors? Contracts with a minor will be binding unless repudiated if they relate to property of a permanent nature, okay? So interests in land, obviously, that's real property. Purchase of shares, that's personal property, and you'll be doing that in property law later on. Purchase of business goodwill. Business goodwill is also considered a proprietary interest. So where you have contracts relating to any of those things, it will be binding against a minor unless that minor repudiates that contract. Also, contracts that have obligations of a continuing nature. So not like a sale and purchase, agreement where I give you money, you give me stuff, and we're all done. But where we have an obligation continuing over an extended time frame, like a partnership agreement, that kind of contract will also fall into this category, okay? What is involved with repudiation or affirmation? Okay, repudiation, don't want it anymore. Affirmation, yes please, I'd like to keep that, okay? Need to repudiate within a reasonable time because otherwise you might be held to have affirmed the contract just purely by virtue of your delay, okay? So in Hamilton and Lethbridge, 2 years was enough to constitute affirmation and the minor couldn't repudiate. Edwards and Cardiff, they said 4 to 5 years was more than ample for the court to hold that there had been affirmation, okay? So you can't sit on your rights here. If you're going to repudiate, you have to do so reasonably promptly. Now, the legislation does have some impact here. Certainly in New South Wales, you can only repudiate until your 19th birthday, okay? So there has to be a cap on which this contract is vulnerable to repudiation, so to speak. Okay, so those are the other category of contracts that may, in fact, be binding against a minor. You'll see that the text discusses a ragtag bunch of other stuff in relation to minors. Generally speaking, minors will be liable for torts. Why is this? Because torts are all about keeping society as a whole pleasant to live in terms of having due care for others, okay? However, where a minor has committed a tort and to bring them to account for the tort would effectively mean enforcing an otherwise non-binding contract against that same minor, then they're not going to be liable, okay? Have a look at the Leslie and Shield case that the text talks about there. Restitutionary claims, the text also talks about those when you can and can't get goods or money back from a minor if there has been this issue of some kind of tortious deceit involved in procuring the contract by the minor. Very narrow, again. You can get your goods back if those goods are in the minor's possession still, and only then. In terms of money, you can only get your money back from the minor if there's been some kind of deceit, if those actual coins or notes are still in the minor's possession. Why is it so narrowly constrained? Because if you could just get your stuff back without these safeguards around the process, it would be effectively enforcing a non-binding contract. Have a look at what the text says about that. Also, in relation to restitutionary claims against minors, you'd have to bear in mind that the legislation also cuts in here as well. As I said before, I'm not going to be concentrating on restitutionary claims in terms of this unit, but do bookmark it as something of interest that is an area outside contract law that you may have recourse to in order to try and get stuff back if things go wrong with a contract. We'll be talking about that, as I said, in contract B. So again, I think this is probably where we should leave part 2 and come back and see me for part 3. Bye guys.